Okay, I've been pretty busy filing with the U.S. Supreme Court, and people may wonder, well, what is Steve doing? Uh, Elections coming up. Tina Smith is running. She's been involved in this case with Keith Ellison of taking away the cancer treatment coverage from women that are in a federal program. And so I just want to share with you the questions that we're bringing before the U.S. Supreme Court. We expect Keith Ellison to answer and not to just wave and hope that the court just dunks these women. So here are the three questions. The first one is whether the applicable plain and ambiguous language in light especially of an Idaho case called Hauser versus Idaho Department of Welfare and of Congress's federal statute. Now this is the Breast and Cervical Cancer Prevention and Treatment Act. It's 42 U.S.C. 1936 AA. And they also have a limitations period which specifically says how long this lasts. And that's 42 U.S.C. 1396 A10 G14. I mean, this is hard to even find. Or whether the Minnesota State Legislature's conforming statute is called Medical Assistance for Breast and Cervical Cancer. It's Minnesota Statutes 256B.057, subdivisions 10A to C. And I'm setting this out here because I'd like people around the country to join us in amicus curiae brief. Now, we're not lawyers. We would like lawyers to help. Now, whether these laws require or even allow the removal of the appellant as a patient in these government breast cancer treatment payment programs from her Medicaid MABC coverage, either after her husband's 65th birthday in July 2016 when they did terminate her coverage, to on her 65th birthday in November when respondents say they could have or should have terminated it, or 3, on July 1st, 2017, a whole year later, to the present, because they terminated again. They kept extending it because they knew they were wrong. And she has not yet finished receiving her required cancer treatment. So in light of two U.S. Supreme Court cases, Keysar and Azar, should a state agency like Minnesota Department of Human Services be deferred to so much that they try to use the funds of a federal program to overcome the want of local funds endangering patients? Now then, the second question is whether in reviewing the appeal of the termination of MABC and transfer to the medical assistance for the elderly by the Ramsey County respondents or Minnesota DHS under the state's Administrative Procedures Act, and that's Minnesota Statutes 1463 to 69, really. Did DHS and the state courts violate the federal Medicaid requirements for a fair hearing? That is 42 U.S.C. 1396 A3, and the constitutionally required procedural due process under the 14th Amendment due process clause is set forth in this court's, that's the U.S. Supreme Court's, Goldberg versus Kelly, Regents versus Roth, Pediatric Specialties versus ADHS, that's the 8th Circuit in Arkansas, and related cases when they deprive petitioners of their right to prior notice of the county's action and the county's reasons for transferring her and the spouse to a harsh spend down of 20% below cash poor level each month instead of her cancer treatment coverage. Whether Minnesota's post-deprivation proceedings, which now rely on Matthews versus Eldridge, and various Minnesota due process practices have substantially remedied that initial flawed procedure which deprived her of her statutory entitlement and constitutional and fundamental rights. And finally, the third question, whether petitioners under the APA, that's the Administrative Procedures Act of the state of Minnesota, may pursue remedies for violation of federal constitutional rights under 42 U.S.C. 1983 for damages against Ramsey County respondents or for declaratory or injunctive relief against the Minnesota DHS for violation of constitutional rights. 14th Amendment, procedural, substantive due process, equal protection, arbitrary and capricious denial and injury, or privacy in the administration of her MABC and BCC PTA. That's Breast and Cervical Cancer Prevention and Treatment Act, year 2000, from the U.S. Senate. That's Amy Klobuchar, and also the U.S. House. That's people like Betty McCollum. And did they violate her right by requiring unwarranted payments for her cancer treatment from both spouses down to 80% of poverty income monthly? That's 20% below those who can walk out and get monthly payments, cash payments from Hennepin County or Ramsey County welfare. So they have to be very, very poor indeed to get any further help from Keith Ellison in the state of Minnesota. And is Minnesota and Ramsey County by 1983 required to pay her right now her MABC benefits and other damages to be determined in further proceedings? So these are the things that I've been busy forwarding to the U.S. Supreme Court. And I think that if you read what the Minnesota Appellate Court and Supreme Court have allowed, this is ridiculous, and it cannot withstand the light of Supreme Court review. And we truly ask for that. And we ask you to come to this case, which is posted at the U.S. Supreme Court. It's called Victoria Carlson et Veer Petitioners. That's the one from last year, and this is the merits case. Thank you for listening, and please get on this. Many people around the country know this is wrong, and they have given their support, and we need amicus curiae. Thank you very much.